Hello and welcome to Compliance Briefs on Record Keeping. This video will cover key aspects related to the retention of records. Next, we will discuss the format and retrieval of records. The use of electronic files will be examined, particularly in relation to compliance and regulatory requirements. We will also address group-wide policies on record retention, ensuring consistency across business units. Finally, we will cover potential penalties for non-compliance with record retention regulations. You are required to retain certain records and information for 5 years after the end of a business relationship with a client or after the completion of an occasional transaction. This includes copies and information necessary for compliance with the client due diligence, evidence of both domestic and international transactions, client correspondence, and any suspicious transaction reports or suspicious activity reports. Additionally, records of internal reviews performed by the compliance officer, findings, and communications with MOCAs must also be preserved. In cases where it is reasonably justified, such as for the prevention, detection, or investigation of money laundering or terrorist financing related to ongoing criminal proceedings or suspicions, the retention period may be extended by an additional 5 years, bringing the total to a maximum of 10 years. Records can include data obtained through approved electronic identification methods recognized by the Republic of Cyprus. These records must be visible, legible, and of sufficient content and quality. Firms should implement efficient processes for timely retrieval of records, ensuring that access is provided without unnecessary delays. Additionally, companies must establish a record retention policy that complies with the law and GDPR, categorizing records and assigning appropriate retention periods. This policy should apply to both electronic and paper-based records, ensuring data protection standards are met. Firms frequently utilize electronic files of KYC, Know Your Customer documents, such as passport copies, utility bills, and corporate records, as part of their regular operations. These electronic files play a crucial role in maintaining an efficient record-keeping system. However, in the event that MOCAs, ICPAC, or any other competent authority request verification, firms must be able to present the original documents or certified true copies of the originals to validate the authenticity of the electronic records. An ICPAC firm within a group that follows group-wide record retention and data protection policies for anti-money laundering and countering terrorist financing purposes must ensure these policies fully comply with the law. The policies must meet or exceed the minimum standards of the law and the ICPAC AML directive in all applicable locations and jurisdictions. If third country legislation prevents the enforcement of equal or stricter policies, the firm must notify the institute and implement additional measures to mitigate the heightened risk of money laundering and terrorist financing. If any person, during the client identification and due diligence process, knowingly provides false, forged, or misleading information regarding the identity of the client or the beneficial owner, they may face serious legal consequences. This includes imprisonment for up to 2 years and/or a financial penalty of up to €100,000. Such actions are considered severe violations and can result in significant penalties under the law. We hope you found this useful. For any queries, you may contact us at compliance@icpac.org.cy. Thank you and goodbye.